So HIPAA has a redisclosure provision that says protected health information is necessary for patient care across the healthcare continuum, so that as we move forward in handling a person through the healthcare milieu, we create a master record in effect that includes all this data, and that data can be shared as necessary going forward, be redisclosed as necessary going forward, to make sure that all of the data necessary to handle this individual through the healthcare system is available. This is what we call generic disclosures, which really don't need further client permission and can, in effect, be considered and could impact juvenile justice data sharing. One of these generic disclosures that we're most concerned about controlling and making sure that healthcare providers and juvenile justice providers understand is that a healthcare agency may provide healthcare information, PHI, as appropriate for the oversight of healthcare system activities for certain government benefit programs and to entities who are involved in regulatory programs subject to civil rights laws, and also to law enforcement and to judicial and administrative agencies for the purposes of preventing or lessening a serious or imminent threat to the health and safety of a person or of the public. But, again, the words here that we're looking at on redisclosure is not just providing the entire health record to whomever asks it for, but providing it for a specific reason to help prevent and lessen a serious or imminent threat. There is a frequently asked questions page on the HIPAA site, which provides a number of frequently asked questions and answers, as well as some opinions and some information that is very important for consideration when you are looking at disclosure and redisclosure of HIPAA data throughout the juvenile justice system. Two of the questions that we found to be most specific were the ones that deal with the scenario we just said: can a child's record, which is compiled by a series of providers, be provided to the parent? And the answer is yes. The second one is shown on this page, which says, does the privacy rule permit a covered entity to use or disclose protected health information pursuant to an authorization form that was prepared by a third party? And the answer is yes. The covered entity is permitted to use or disclose that protected health information pursuant to any authorization that meets the privacy rule's requirements. The privacy rule requirements do say that initially there must be a consent, but they do not specifically identify who needs to form that consent and who needs to sign it. There's also recently been a high-tech rule that addresses redisclosure under HIPAA. And this is where the HIPAA high-tech rule, while it addresses redisclosure, does not differentiate between manual or electronic record sharing. So if the medical record that you're looking at for the juvenile justice assessment is being shared, being redisclosed, it is really under HIPAA not relevant whether that record is electronic or whether that record is manual. More importantly, you need to define if what you are sharing is a complete medical record, medical history, or if it is just results of a specific treatment, results of a specific diagnosis. Some more FAQs to look at regard whether a portion of the record can be shared, if it concerns older information, whether it was created by another agency or by another provider, by another medical. And again, we've answered this in the sense that you are able to disclose this complete medical record. But remember that initial disclosure and that initial consent form that was signed to allow that initial disclosure must indicate that there may be redisclosure, and at that point, it may no longer be covered by HIPAA. So now let's turn to a discussion of FERPA redisclosure. FERPA does define disclosure and redisclosure. Disclosure is defined under FERPA as to permit access to or the release, transfer, or other communication of personally identifiable information contained in education records by any means, including oral, written, or electronic, to any party except the party identified or the party that provided or created the record. Under FERPA, we have authorized disclosures which allow or permit specific users and uses of personally identifiable information in student education records without the written consent of the parent or the eligible student. We have unauthorized disclosures which are situations where personally identifiable information from a student's education record is made available to a third party who does not have the legal authority to access that data. And we have inadvertent disclosures where information is unintentionally or inadvertently revealed to the public or released to the public. As FERPA is a federal law that gives parents, guardians, and some students access to their education records and the right to seek and have the records amended, FERPA deals with not only disclosure of records, but redisclosure of records. The term education records is defined in FERPA to include information directly related to the student that is maintained by an educational agency or institution or by a party acting for the agency or the institution. So this would include disclosures made of FERPA-protected data that includes education records and also records such as school nurse records or records relating to financial aid or information about the behavior of the student. However, there are several exceptions to FERPA's prohibition on disclosure of educational records. In particular, FERPA provides specific exceptions for disclosure of disciplinary records in certain circumstances, and these are relevant to the juvenile justice data sharing and redisclosure area. FERPA permits the disclosure without consent and the redisclosure without consent of disciplinary records to other school officials who have a legitimate educational interest, officials of another school system or institution where the student is seeking to enroll or being enrolled, in connection with any kind of financial aid application, to accrediting organizations for the particular educational institution, in connection with a health or safety emergency, consents to the parent of the dependent student to actually see the information about their child, for information that is designated as directory information and thereby is not considered personally identifiable information, to the parent of a student if the student is under the age of 18 and has not yet enrolled in any post-secondary institution or college, to an eligible student after they reach age 18 and are enrolled in a post-secondary education institution or college, if there are state statutes which allow state and local officials or authorities to receive that information, and to organizations who are conducting approved studies. Now, the organizations conducting approved studies are further broken down into FERPA to address organizations that are doing evaluative studies where personal information is involved, or organizations that are doing aggregate data studies. There is also an authorization to release information without consent under FERPA to the Comptroller General, the Attorney General, and the U.S. Department of Education. Now let's move further and look at some FERPA redisclosure provisions. The FERPA disclosure and redisclosure provisions say redisclosure is to a third party, not a school official at your institution, to whom you provide an educational record, a disclosure, who is now going to redisclose that record to a third party and possibly others. In this case, the authorization is valid if the third party has consulted with the institution. In other words, the institution knows why they want this information and has told them what they're going to be using this redisclosure for, that it falls under one of the exceptions under FERPA, which is the 34 CFR section 99.31, and that it is recorded that it is going to be a redisclosure. And this recordation can happen on the initial consent form or on a secondary consent form, but that recordation has to list the details. Who is the information going to be disclosed to, and what are the legitimate interests that prompted the redisclosure? Legitimate interest is the word that we use under FERPA, similar to health and safety emergency under HIPAA. FERPA is, as you know, a federal law that gives parents and guardians of elementary and secondary students, as well as post-secondary students who are no longer classified as minors, the right to have access to their education records, the right to see those records, to amend them, and to have some control over who that information is disclosed to. Educational records, as we said, is defined very specifically in HIPAA as that information related directly to the students that are maintained by an educational institution or agency or by a party acting for the educational institution or agency. A party in this case can include the school nurse. It can include a school counselor. Under FERPA, school may not generally redisclose personally identifiable information from a record without consent, and that consent has to be written. However, we said there are some exceptions. The exceptions on consensual, non-consensual redisclosure deal specifically with disciplinary records in certain circumstances, authorized disclosure to other school officials who have a legitimate educational interest, officials of school systems or institutions where the student seeks to enroll in the future, in connection with financial aid and accrediting programs, in connection with health or safety emergencies, to parents of dependent students, if that information is designated as directory information, and to state and local authorities and officials under state statute, as well as to authorized representatives of the Comptroller General, the Attorney General, and the U.S. Department of Education. Protecting student privacy and revisions to FERPA currently underway and up for comment on the FERPA website are looking to further protect this student privacy, so that under Section 99.30, we're looking to define further under what conditions is prior consent required to disclose and redisclose information. As it stands right now, except for the specific exceptions mentioned, a parent or eligible student must sign and date a written consent before the school can disclose educational records. That has to specify what records can be disclosed, the purpose of the disclosure, and identify any party or class of parties to whom disclosure or redisclosure may be done. This includes organizations that may be conducting research on or behalf of the school. Some of the exemptions included in there are to state and local officials in connection with serving the juvenile under the juvenile justice system established under state law. This exemption is one which will impact the juvenile justice information system the most, as it is interpreted and structured into policy at the state level, not at the federal level. So let's take an example. What if a school official wants to contact a child's doctor about an inaccuracy on a doctor's note? Does the school need to get special permission from the parent, or can they contact the doctor directly? Well, this is where a little bit of a change occurs in FERPA, different from HIPAA. But if you look at it, it's a actual very close to what HIPAA does, where a record can be transferred for referral. Under FERPA, the regulations changed the definition of disclosure in 2008 to permit a school to contact the stated source of a record, such as a doctor for a doctor's note for verification purposes, without consent. This is not considered a redisclosure under HIPAA or under FERPA, and therefore it doesn't violate FERPA. In other words, FERPA allows an educational institution to have a targeted release of records back to the stated source if it's for verification purposes. This provides schools with flexibility needed in general to handle things like doctor's notes, like checkups on particular programs, without having to go through a formal consent process. However, the initial consent form that was signed by the parent to allow release of data should again address that under the privacy rules, depending on how the doctor's note is addressed, the doctor can respond to the inquiry saying, yes, we wrote that note, yes, we said the child had a contagious disease, and that's why they shouldn't be there. But all of the details going forward need to be discussed under HIPAA, not under FERPA. So under FERPA, there are some redisclosures for targeted shared information that do not require consent. Additional sites to FERPA in specific instances are provided as part of this presentation, and you can also look at the FERPA website, the FAQ site for FERPA, and at the Family Compliance Office listserv at FERPA, which will provide up-to-date notices as to changes in FERPA and how often these changes occur. There are also a number of guidance documents available on the FERPA website which address specific situations and scenarios. And further webinars on this topic will be using specific use cases from collaborative organizations and states that have attempted to move forward and deal with more consent and data sharing between schools and other agencies, including producing memorandums of understanding, and producing data sharing guidelines and matrices for users of FERPA data.